Wills, Inheritance and Family Property Disputes in Nigeria. Episode 1. What makes a will valid in Nigeria? Welcome to episode 1 of our legal education series, Wills, Inheritance and Family Property Disputes in Nigeria. Today's focus is simple but powerful: what makes a will valid in Nigeria? Why is this important? Because after a person dies, especially someone with land, houses, or business, and sometimes large Nigerian family, the family is often left in confusion or conflict, mostly because there is no legally valid will. What is a will? A will is a legal document written by someone called the testator to explain how their property should be shared after they die. Note that it takes effect only after the testator's death. Through a will, a person can choose who gets what, e.g. land, houses, money. Appoint guardians for minor children. Protect a spouse or dependent. Even give instructions for burial. But all of this only works if the will is valid. Legal requirements for a valid will. Let's break this down. Under Nigerian law, for a will to be valid, the following conditions must be met. 1. Age and mental capacity. The testator must be 18 years or older, except some special categories like soldiers or sailors. Must be of sound mind, able to understand what they own and who they want to give it to. 2. Voluntariness. The will must be made freely, not under pressure or influence. If someone forces or manipulates the testator, the will can be challenged in court. 3. The will must be in writing. Wills should be written. Oral wills are allowed only in rare cases under customary or Islamic law. 4. Signature of the testator. The testator must sign the will, or acknowledge a signature made on their behalf. 5. Witnesses. 2 people must witness the signing. They must both be present at the time the testator signs. They must also sign the will in the testator's presence. Important: if a person who benefits in the will signs as a witness, their benefit can be cancelled. Common reasons wills are invalidated. Many wills are rejected by courts for the following reasons. Undue influence: someone pressured the testator into writing the will a certain way. Fraud or forgery: the signature or document was faked. Lack of proper witnessing: for example, only one witness signed. Incapacity: the testator was mentally unfit at the time. Unclear language: poorly written wills can cause disputes. Practical tips for making a valid will. Here are simple steps to take. Use a lawyer to draft the will properly. Keep the will in a safe place or register it at the probate registry. Update the will when your life circumstances change. Never use a beneficiary as a witness. List your assets clearly. Avoid vague statements like, "all my things." Conclusion. So, to recap, a valid will must be made by a mentally sound adult, written voluntarily, signed properly, and witnessed by 2 people. A will brings clarity and peace. But an invalid will brings confusion and fights, sometimes for years. In episode 2, we'll talk about what happens when someone dies without a will, and how property is shared by law in that case. Thanks for watching today's episode on Legal Guide TV. Remember, knowing the law is the first step to protecting your rights. If you found this helpful, like the video to show your support. Subscribe and turn on notifications so you never miss an update. Share this video with someone who needs it. Comment below with your questions or topics you'd love us to cover. At Legal Guide TV, we're committed to helping you do it the right way, legally. See you in the next series.